Hi everybody. Today we're going to talk about those standalone retirement trusts. We've talked about estate planning with retirement accounts before, but today we're going to go a little bit deeper, take more of a deep dive. And I'm Michael Redden. And if you have any comments or questions about this topic, please put them in the comments. We'll get back to you. This is where you can ask those in-depth questions, those more complicated ones. Additionally, if you want to plan with me or if you'd like to talk to me in person about it, click on the link in the description or go to reddenlawoffice.com, click on schedule a planning session. You'll go right to my calendar scheduling, select the day and the time. It can be over the phone or in person. So standalone retirement trusts, they are really a special thing for your retirement accounts. But first, let's talk about retirement accounts in general, really. Retirement accounts are better known as qualified accounts. They get these special tax deferrals, right? They can grow and they can grow tax deferred, and then at some point you take money out of them and that money might be taxed, or if it's a Roth it won't be taxed. But that growth phase, no matter which kind of account it is not taxed, and they're meant for retirement. Now, if you were to die and pass away with one of these accounts, there is an inheritance piece to it. You can have them inherit down to your spouse or your kids without going through a trust or anything like that. But they're different once they're inherited down. A lot of people might know what RMDs are. Those are required minimum distributions. Basically, at some point, since these are made for retirement, we're not going to want you to let these grow tax deferred forever. Congress decided we made these for retirement. So at a certain age, you've got to start taking that out, realizing that gain and paying us some taxes on it, because the only reason we let it be deferred is because it's for retirement. Normally, when you pass away, any kind of tax gain and tax consequences are gone. Your heirs don't have to deal with those except for maybe the estate tax. That's not what Congress wanted for these. So when it goes down even to your spouse and things, or even better yet, when it goes on to your children, if your child's 40, then we're going to say, you're 40. We think based on our math, you'll live another 30 years. So you have to start taking money out over these next 30 years, and with the goal that in 30 years, all the money's out. It continues to grow. The stuff that you don't take out grows for that next 30 years. It grows without you paying taxes on it, and that's a really good thing. But it's going to come out at least enough on a schedule to be completely gone in 30 years, and you're going to have to pay taxes on those things. Now, the trick to this comes when there's more than one child that's there. We can get our head around that this is for retirement, and our spouse and things who get it after us are going to have to start taking it out right away over their lifespan. Well, when there's more than one kid there's a couple of ways we could have set up that distribution schedule. It could have been out to one kid 25%, another kid 25%. That's different. But when we say just give it to my kids and they're a class like that and there's more than one, then we're going to say it goes out based on the oldest lifespan. So even though it's 50-50 with a 25-year-old and a 35-year-old, we're going to have that 25-year-old have to take money out based on the lifespan of that 35-year-old, so they don't get as much grow. This growth over time and things like that, moving those payments out to when you were supposed to pass away based on our math, that's called the stretch. And anytime that you're dealing with retirement accounts and planning with them, you're going to probably plan, number one, to preserve the stretch. And if you've dealt with a financial advisor, financial planner, or anything like that, they're going to really be interested in the stretch as well. But there's another aspect to it that is kind of different now. We're used to the fact that most of the time our retirement accounts, they're sacrosanct. They can't be touched except maybe in divorce. In divorce, we're used to, that those things get split up with the spouses. But creditors, they usually can't take them, at least if they're 401ks and things like that are covered by that federal law known as ERISA. IRAs, they're not covered by ERISA, and they go from state to state. And Minnesota only protects those up to $69,000 in them. Any money in there above $69,000, your creditors can take. And even if you had to do that ultimate thing of going bankrupt, chances are you can protect most of your retirement accounts. That's not true for inherited retirement accounts. The Supreme Court had a case not too long back, And what they basically decided was, for the spouse, they're probably still going to use this money for retirement. And really, when you put money into retirement accounts from the spouse unit, from the husband and wife, it could have been the husband's money, could have been the wife's money, but it's for retirement. They really should protect that. So we're still going to protect that for your spouse. And once it goes to your kids and things, can we really say it's for their retirement? I mean, they might be 25 or 30 or 40 and they're taking this money out. Sure, it's stretched, but it's not for retirement. They're not spending that on retirement when they're 40. And so, since Congress wanted to protect these things because of retirement, the Supreme Court said, at least in bankruptcy, we're not going to treat them that way. So in bankruptcy, this inherited thing can be taken, and it can be taken in your heirs' divorce and things like that too. And lawyers are starting to try to use this reasoning to get other states to let them get at the retirement accounts for other reasons, for just run-of-the-mill lawsuit and debt kind of things. And they're having some success with it. A way to handle this is with the standalone retirement trust. Because, one of the big principles of asset protection planning is to separate yourself from your money and your money from you, so that what hurts you doesn't hurt your money, and sometimes what hurts your money doesn't hurt you. And that's kind of what we're looking at here, because when we make a standalone retirement trust, we're never the beneficiary. It's intended to be an estate planning tool. In fact, our IRA is not even going to be owned by it. It can't be. It's just inherited down into it because it's the beneficiary. So it has that extra element of it is not ours. It belongs to the trust. So it can't be split up in divorce. It can't be touched by our creditors and things, and that's very important, and it's very desirable, especially if our heirs aren't ready for that money. If our heirs are going to spend it frivolously, because without that there, they can just go cash the whole thing out, and that's one of the things that the Supreme Court said a lot of them do. And so it's not used for retirement. But it's so powerful, and it affects their livelihood, and it affects their retirement and their wealth so much if they can stretch that out as much as they can. And once it's inside that retirement trust, it could even become dynastic, which brings us to the next thing we kind of need to talk about, and that is the tax kind of issues with these trusts. Now, if the trust just takes the distribution and gives it right to the heir, takes it and gives it, takes it and gives it, it doesn't sit inside the trust like that, then it's going to be taxed on the heir's income tax. So it's going to be at their tax rate and things like that. No big deal. The trust acts as a conduit, and it's called a conduit style of trust. The next kind of trust that kind of goes with this is, well, if the money comes in, but I as a trustee don't write it right out to the beneficiary. And this can happen sometimes to conduit trusts if, well, nope, we're not going to pass it out because that heir now has special needs and I want to hold on to it so that they can have benefits, or now there's a creditor out there who's trying to levy on things and I've got to hold on to it. In that case, sometimes depending on how they're written, it can still be taxed at the heir's level. But the heir didn't get the money. They might not have the money to pay the taxes. So a lot of times it's best to have it sit inside the trust then and be taxed at the trust level. Trust level's a little bit higher, but it's still probably better than having that money come out, be lost in a divorce, go to a creditor, something of that nature. And it's definitely better if they get special needs later on for it not to come out and then make them ineligible for government benefits. Because chances are if they're in special needs or they're in a home, they're going to need a lot more money from the government, a lot more assistance from the government than would be for the entire amount that's in that retirement account, and we want to keep it going that way. And with accumulation trusts, they can still grow and be invested once it comes out of the IRA. It's just it's not tax deferred anymore. You're going to recognize gains differently, but it can become dynastic there. If you were lucky enough to have, say, a $5 million IRA, and they end up only using $2 million in their lifetime, now that money, that lesser $3 million, can keep going down to grandkids and others, and it just keeps going and going and going, and it can grow to phenomenal amounts that way. It's a great way to kind of start a legacy. But you need to know these kinds of things, these nuts and bolts, when you talk about this with your advisors or attorneys, because you should know that the two big things that we plan for at this is preserve the stretch first, and then second is asset protection. That also includes government benefits, so we can put kind of like a third piece for that. So you need to know how to talk to them with it. Do they need the standalone retirement trust? Is it going to be a conduit trust or an accumulation trust? Who are the beneficiaries? Does it provide for special needs? And remember, if the heirs aren't ready for it, in that accumulation trust, you can say things like, don't pay for that Ferrari. Don't let them have big, large parts of cash. Check and make sure that they can't afford this on their own first, even if it's a need or a kind of want. Or you can say, be generous with it. You get to have those same kinds of controls, and it's on your major asset. So those are the reasons why you would really want a standalone retirement trust. That's the basic overview of how they work. They're not going to own your IRA. You're still going to own it. They're going to be the beneficiary of your IRA. And it's something we add on to the base level of our estate plan. Our basic estate plan has that will, that revocable living trust, our healthcare directive, and our power of attorney. This is going to be added on top of that. And it's to handle that special asset. Remember, we have those extra trusts in there when there's special assets that are involved. So, again, if you have any questions or concerns about this, leave them in the comments below. This is a lot of meaty information, even though we've only gone about 12 minutes or so. We hit just the highlights, and we can get as deep as you want in those comments. If you want to plan about this or you want to talk to me about it in person, click on that link and go to my calendar and schedule a date and time, and we can do that. Or you can go to reddenlawoffice.com, click on schedule a planning session, and do the same.